I'm here alone with anyone to keep me company tonight, and no one to ask me asinine questions. And so what I'd like to do is reiterate. You're at the Cinderfella Show, live in the metropolitan area radio stations and abroad. This radio station tonight is going to be primarily on the corruption with the district attorney in Queens County, Bryce Benjamin and Melinda Katz. They made an undisclosed deal. I shouldn't say undisclosed deal at this point because I got into a conversation with the attorney who was representing me pro se. He texted me a message after I was telling him about all the things that I was doing concerning trying to get the affidavits that he wasn't trying to get. And he confided in me with an omission of guilt, saying that, I'm going to read it, and he texted a message to me. He said, I was hired. I'm reading from a hard copy of what I snapshot from his text, and it states as follows. I was hired as conduit for being go-between you and Bryce and DA, meaning Melinda Katz, to get at physical evidence and test it, but as of now, no evidence to test. So that ends my participation. Now, the unethical thing about this is that the district attorney, in no form or fashion, can intervene with the attorney and a client in that manner, pay an attorney off to abort his client's representation. Eric Kleiner accepted some bribery money not to litigate a 440.10 motion, evidence that shows that the sole eyewitness, when he was standing with District Attorney Bryce Benjamin, where this witness said she saw me and other people perpetrate this cab murder at a distance that was humanly impossible. During the inception of our meeting at the crime scene, I had my phone out, and Bryce Benjamin told me to put my phone away. And Attorney Eric Kleiner, he also agreed. He said, yeah, put that away. And Bryce Benjamin told my video technician not to video his investigation. I winked and blinked at my video technician, and we captured the whole crime scene. So now, I was standing where the homicide took place, and when the homicide transpired, there's a surveillance camera. But the jury was never shown the footage of the surveillance camera, quite naturally because I wasn't on it. Now, common sense dictates, if there's a murder in front of a surveillance camera, the police, the detectives, that's the first thing they're going to want to do is look at the footage. And because I wasn't on it, they withheld that exculpatory evidence. There's a second crime scene where they found this man's car a block and a half away. The door open, keys in the ignition. The cab driver was CB on the front seat, car seat. So it looks as though a chase took place. It was a prostitute-prone area where guys in cars pick up prostitutes and they bring them various places in Long Island City where it's dark. They said that my co-defendant, this guy, they said he was my co-defendant, and me and him didn't even get along, so we didn't even talk when we was out in the street. I didn't talk to him. I seen him around, but me and him had an argument one time, and we just stayed away from each other. So anyway, she said that this sole eyewitness, a prostitute, drug addict woman on life probation for drug sales, and she was an out mental patient. They made an undisclosed deal with her because she had a pending drug trafficking case. She was facing 20 years to life, and she had about 4 or 5 kids. And so they didn't need a full court press to get her to lie for them. They gave her a script in which she fouled it up. During trial, she said this man's cab was a yellow cab. The cab driver was driving around looking for a prostitute. She said she was in this man's cab a week prior discussing the prices of sex acts, but didn't do anything. On the night of this homicide, she said he was driving around trying to pick up prostitutes, and that was at 8 o'clock. She walked around 4 blocks. She didn't speak to anyone. She didn't get in the car. She didn't take a nap. She didn't go home. She didn't go to the restaurant. She just strolled around 4 blocks. And so when I came home on parole, I went to the location where she said she saw this, or overheard this conversation about me and this guy talking about ripping off a cab driver who was in a car driving around. How did you do that? How are you going to rip off somebody who's driving around in a cab and you on foot? You don't know where this man is going to stop his car at or anything like that, but out of the clear blue sky, they put this narration, manufactured, fabricated lie, and they got her to say this. And then, so, all of a sudden, it's 1 o'clock, 8 o'clock, 9 o'clock, 10 o'clock, 11 o'clock, 12 o'clock, 1 o'clock. Several hours to walk around 4 blocks. That took me 10 minutes, less than 10 minutes to walk around 4 blocks. That's a huge discrepancy in the hours of her so-called, she walked to the scene, a location of where she said she saw this homicide being perpetrated. Now, the observation distance was humanly impossible. My technician and I, we was walking towards them and they was walking towards us. And my video technician kept saying, "Where are they? Where are they? I don't see them." And he kept on saying that. And it took a very, very long time for us to finally meet because they was walking towards us and we was walking towards them. So when we finally met up with each other, Attorney Eric Kleiner said to me, the only thing he could see was the light on my phone, because I was waving it from side to side in the air. And you can see that on the video. And you can look at and see Bryce Benjamin. He didn't make a comment, but he was laughing. He had a crap-eating grin on his face. 32 years, my 32 years in prison didn't mean anything to him but to be laughed at, because he knew for a fact that the case that they took me to trial was a lie. He looked at the police reports. He saw that that witness had told a homicide detective that she didn't see anything. And he just witnessed that it was a physically impossible identification. Now, before we get to this point, when I got on the crime scene, I had a short discussion with Eric Kleiner, attorney Eric Kleiner, and I showed him my binoculars. I said, I'm going to get his binoculars to Bryce Benjamin, DA Bryce Benjamin. He said, that's more than 2 football fields. More than 2 football fields away. We was talking about the ID. They saw our witness was standing. So when I approached DA Benjamin, I offered him my own binoculars. He told me, I still won't be able to see you with them. So that is a direct indication that he had came to that crime scene and checked it out. When I first met Bryce Benjamin, it was at Al Sharpton's organization. He had a team of people going to be interviewed with by a guy named Nolan Farrell about his wrongful conviction. And I asked to speak to him. And he agreed to speak with me. I told him that I had the documents with me, that I reacted to cab murder, and I still with a sold-out witness standing. And I asked 2 college students, if I'm standing here, would you be able to see me 15 feet away from the far end of that corner down there? And the female said, oh, no, sir, that's too far. And her comrade concurred. Yeah, that's too far. And I went in the daytime. The homicide had transpired after midnight, after 1 o'clock. Under poor streetlight conditions. My lawyer, he's the one that sold me out. The witness had proclaimed she was in this man's cab a week prior, discussing the prices of sex. She didn't have sex with him. She described the cab as being a yellow taxi with a Marlboro sign on the roof. That was an erroneous description. The man that got murdered had a cab that was private owned, and it was black. She also didn't know whether the homicide transpired on the homicide scene map. She got that wrong too. And a lawyer said, wait a minute. You said it's a yellow cab, but the cab is actually black. And now you said somewhere out in the middle. Did you know it was 15 feet at the far end of the corner? She put her shoulders up in the air. And the lawyer said, wait a minute, did somebody make a deal with you to testify against these defendants? And she said, yeah, well, one's supposed to go like this. And the district attorney jumped out of his seat like a jack in the box and shouted, "I object, Your Honor!" And the judge, she tilted her glasses down on her nose, pointed to the stenographer, and told the stenographer to strike it off the record. Jury to disregard this witness statement. She's been on the witness stand for an hour and 15 minutes. We're going to adjourn this case over the weekend. If anyone's to approach you about this case, notify us immediately. And soon as the jury left, they ran into the judge's chambers, and they were screaming and hollering in there. And so when my lawyer came out of the room, he had a scratch on his face, noticeable. And he had his necktie draped over his shoulder. I guess that may have been an indication that I was going to get ready. I was going to be hung in that courtroom with no evidence. So anyway, they had appointed an investigator, but my lawyer didn't use it. The investigator would have went out to the crime scene and took photographs of the crime scene the way it appeared, in the dark. And he would have came back and told the jury that he stood where the witness was standing, and there's no way in the world that anyone could make an identification of anyone at that distance. But they didn't want that exculpatory evidence told to the jury. So my lawyer went out in the daytime and took photographs of the crime scene. He had his daylight photographs shown to the jury as exhibits. A total deception of how it actually looked. He sold me out. There was no evidence. He came up with a bogus affirmative defense and told the jury that I didn't know my co-defendant possessed a gun and was going to intentionally shoot and kill the deceased. Prior to him coming up with this affirmative defense, he touched the side of my hair and he said, "What are you going to be when this is over?" I said, "What do you mean?" He said, "Oh, just in case something goes wrong." And so I looked at him. And so, evidently, he had conspired to do this closing argument to sell me out. He told the jury that I didn't know that William Bradley possessed a gun and was going to intentionally shoot and kill the deceased. Therefore, you cannot convict my client of intentional murder. I rest my case. I had 2 counts of murder: intentional murder and felony murder. I was speechless. It was as though that my mind couldn't process what he had actually said. I was like a situation with a deer in the night. You get hit with some car lights and you get froze. It was something like that I was experiencing, and I was hearing echoes in my mind. O-S, curse word, O-S, O-S, over and over and over and over in my mind. And I'm looking at this guy I went to trial with, and because he said I didn't know he had a gun and was going to intentionally shoot and kill the deceased. So he placed me at the scene of the crime with this guy, as though I told him that I was there, but I didn't know he was going to shoot somebody. I never said anything like that to him. So he sold me out. He sold me out in the beginning. When I first met him in the bullpen, I gave him 2 attorney business cards. And I told him, I said, call these 2 lawyers, Eric Edelstein and Ralph Popkin. Their offices in Queens and one is in the Bronx. Ralph Popkins was in the Bronx. They're criminal lawyers. I made appointments with them, and I told them that these arresting officers threatened to put a murder on me, and they assaulted me. And I made a severe and very bold complaint about it. He took the 2 cards. When we was in front of the judge, I had my head turned, and I was looking for my wife in the audience. I heard the judge say, "Counsel, are you ready for grand jury proceeding?" He said, "Waive." And when he said waive, I spent around and said, "No, I want to go to the grand jury. I want to go to the grand jury." And I said it loud enough so the judge could hear me. Because I was excited. It's like a spontaneous utterance, but it was loud, boisterous. And he put his finger to his lips, and he said, "I got to get the court. He's got to get the court date." And so when he got the court date, the court officers like grabbed me, and tried to rush me out of the courtroom. And I'm screaming to the judge, "Your Honor, I want to go to court. I want to go to grand jury. I want to go to grand jury. I want to go to grand jury," right? But they wouldn't let me go to the grand jury. So we had a Sandoval hearing. That's the name of it, a hearing. And I told the judge, the trial judge, that I didn't want this lawyer to represent me because he refused to give me the documents pertaining to the case. And he waived my right to the grand jury to have 2 lawyers come in and tell the jury that I made appointments with them and told them that these arresting officers threatened to put a homicide on me and had assaulted me. And he refuses to give me the documents pertaining to the case. The judge, she merrily just said, "Mr. Mirsky, will you give him the documents?" And I said, "Wait a minute, I just told you I didn't want him to represent me. I know what y'all trying to do. You're trying to railroad me." She said to me, and this lady's about 80, 90 years old, this judge. She said, "If you say that one more time in my court, I'm going to hold you in contempt." I was furious. I screamed at that judge, and I told you, I just told you that I didn't want this lawyer to represent me. I'm standing here with a lawyer who I don't want to be represented by. He denied me the right to appear at the grand jury. And I'm standing here with no bail. I'm already held in contempt. She screamed, "Get him out of here, get him out of here, get him out of here." So during the trial, you see, the Bible that I read, it says, "What's done in dark will come to the light." Now the witness, she didn't see the homicide because she said it was a yellow cab. She didn't know when the homicide took place. The guy that called 911, he said he thought the guy was hit by a car. He's laying in the street, middle of the street. And he had went back to the scene of the crime, and there's a camera with a light, surveillance camera. The 2 lawyers didn't ask to view the surveillance camera. Now that's exculpatory evidence that's supposed to be, by law, disclosed to the defense prior to the commencement of a trial. Anything that's exculpatory in nature that has a tendency to prove innocence or guilt must be disclosed to the defense. That's the law. It's called a Brady violation. but both of them sat mute. A good attorney would have asked me, Keith, for the last time, I want to ask you, were you there? Because I'm going to ask for it, a viewing of that surveillance camera. And I would have told him, man, I told you, man, I wasn't there, man. And they would have showed a viewing. And they wouldn't have seen me on the view. They'd probably seen some other people. More than likely, they would have seen some other people that perpetrated their crime. Well, anyway, a guilty person is not going to ask for no surveillance camera. I asked for those surveillance camera during the 90s, in the beginning of the 90s. And they refused to disclose that. They certified my entire case file was lost. The entire case file lost. Because I asked for a lot of stuff that were exculpatory. And so now, this attorney, Bryce Benjamin, is trying to proclaim that all the entire case file was lost during the Sandy storm. That's impossible.
I am a non-attorney spokesperson representing a team of lawyers who help people who have been injured or wronged. If you've been involved in a serious car, truck, or motorcycle accident, or injured at work, you have rights, and you may be entitled to money for your suffering. Don't accept an offer you get from an insurance company until you talk to a lawyer. And we represent some of the best personal injury lawyers you can find. Tough lawyers that will fight to win your case. And they're so good they stake their reputation on it by only getting paid if you win. So if you've been in a serious car, truck, or motorcycle accident, or hurt on the job, find out today for free what kind of compensation you may be entitled to. Call the legal helpline right now. 800-796-1182. 800-796-1182. 800-796-1182. That's 800.
They haven't. Yeah, that was it.
Expressed in this program are those of the producers, hosts, and sponsors of this program, and not of the station or the station's owners. The following program is produced by Delwood Crandall and RMAC Incorporated. Welcome once again to Deep Cuts with Delwood. For the next hour, I'd like to play music, much of it new, of an arcane and unusual nature. But that is the purpose of this program, to expose you to music that maybe you've never heard before. And the reason why is because this is the place where the joy of discovery never ends. This program has been brought to you in part by Multicultural Radio Broadcasting Incorporated.
So,
And now, without further ado, let's get into some music.
okay. So, DA Bryce Benjamin, he came back to that scene without his conviction integrity unit on the night of the crime scene investigation. He had premeditated their exclusion with Melinda Katz. They conspired to fabricate a letter that the conviction integrity unit does not substantiate my claim of innocence, and sent that letter to attorney Eric Kleiner. At that point, Eric Kleiner knew that the conviction integrity unit was not there. He was supposed to report this fraud to the appropriate authorities. Department of Justice, the Bar Association, prosecutorial Commissioner of Prosecutorial Conduct, FBI, and whatever agencies that deal with corrupt politicians, elected officials, anyone who perpetrates a crime against the Constitution. He took an oath to protect the Constitution and to ethically and zealously represent clients in criminal matters or any other kind of matter, civil or whatever. Instead of him doing that, he was supposed to write a 440.10 motion, litigate a 44.10 motion, newly discovered evidence that the witness was standing at a distance, humanly impossible, evidentiary hearing on this matter, and to even could have asked the judge to come onto the crime scene also to view it for herself, right? Or he could get a forensic expert to come out there and on the oath and do an analysis of scientific of studies that it was humanly impossible for anyone to make an identification at the grand jury and at trial. And it was knowingly use of perjury because a witness, so-called eyewitness, she was standing at a distance, and she said to a homicide detective that she didn't see anything. They asked for a subpoena for that detective. They also asked for a subpoena for the detective who narrated this case against me. He, all of a sudden, before she testified, they asked for a 15-minute recess, the district attorney. Me and this guy was going back to the detention holding pens, and when the doors opened up, I witnessed them unhandcuff this woman, and Chris DeLuca, Detective Chris DeLuca, he pointed to this guy and he said, "That's William Bradley and that's Keith Gatson." When we got to the holding center, we asked the correctional officers to summon our lawyers, and we told them about this, what they did, a plant outside. So our lawyers requested for a mistrial. It was denied. When the judge denied the subpoenas for the homicide detective and the chief detective who put this case together and narrated it, she denied subpoenas for them and quoted, she said, "Conviction counts." So, in actuality, my innocence didn't have anything to do with trying to seek out the truth. Even when it looked apparent that this woman didn't see a homicide, but they was bloodthirsty to put 2 black men in prison. When I was locked up in Queens detention house, they have a gym there. I saw this guy, William Bradley, bench press 315 pounds, doing reps with it like it was a piece of cake, like it was like it's nothing. He asked me, "Yo, man, you want some of this?" I said, "Man, are you crazy? He had all those weights up there. I'm not getting up underneath that, right? I played basketball. That's what I wanted to do, play some basketball. That's what I do." So anyway, he told me that he had did a bid and and that's what he do, lift weights. So, and he was a big dude, man. He was a big dude. So they said he pistol whipped this victim. So when I got convicted, I was up in Clinton. The lawyer finally sent me the documents to the case. And when I was looking at the autopsy reports and I saw the facial injuries, I said, oh, hell no. He didn't pistol whip nobody, because a gun is made out of steel. And his wrist was so big, they had to use ankle cuffs for his wrist. And he, hands was huge, humongous. If he'd have struck anybody in the face with a steel object, a gun, he would have broke their face, broke bones in their face. But the victim, he had scratches in his face. 3 of them. Like one from a thumb, and the second finger and the third finger, like going down. And the longest one was like 3/4 of an inch. So there's no possible way that this man was pistol whipped. I did a written deposition to find that information out, but they refused to give me that information from the medical examiner's office. So now, the entire case file is lost. Fingerprints out of the database. Anything that connects to actual perpetrators of the crime, they got rid of it. I had got information off the street as to who actually perpetrated that crime. I sent a letter to John Santucci, DA John Santucci, and said, listen, I got information who actually perpetrated the crime. I'm asking for a postponement and check their fingerprints out. So what do you think? They actually, more than likely, they went and checked it out, and those fingerprints matched those 2 individuals. And so they said, okay, this is what we're going to do. We're going to dismiss the case against the female that was indicted with me and this guy. And we're going to keep the 2 guys who were convicted in prison, and we're going to go on and convict these other 2 people, two black people, and we're going to make sure that when they're in prison, they're going to keep them separate so they will never see each other. And so that's what transpired. When I got information off the street, they was actually locked up for cab robbery, but they didn't mention murder. So now, I put in a Freedom of Information Act request for the district attorney's investigation concerning the information that I provided. They ignored it. They ignored it in its entirety. Never responded. When I litigated about the surveillance camera, they never, even to this day, was mentioned or say anything about the surveillance camera. Not even District Attorney Bryce Benjamin. So now, what we got here is we have a lawyer who's supposed to put a 440.10 motion. He writes a memorandum talking about racism, appeal to racism is what this case was in the 80s, and destruction and loss, deliberate destruction of documents, and the district attorney has refused to give affidavits concerning these documents, right? So now, I'm asking Eric Kleiner, why didn't he do a FOIA request, and what is his remedy to get these documents if the district attorney doesn't disclose affidavits, this information that's needed? And then so he said in this letter, I think I read it already, I'm going to read it again. I was hired as conduit for being go-between you and Bryce and DA to get at physical evidence and test it, but as of now, no evidence to test. So that ends my participation. Now, this man, Eric Kleiner, in his memorandum, he said he was representing me pro bono. But now all of a sudden, he's saying in his text message, I told him I have the video, and the DA told me to put my phone camera away, and told my video technician to put his phone, not to video his investigation. He says back to me in reply, I know that. I don't believe the police when they say they have no evidence left to test. That's what I know. Don't throw me in with them, Rev, or we are done. I won't take any text. Why don't you? And he said some other stuff that's got cut off. Now, I asked him, how come he didn't do the 440.10 motion? And he says, no, I'm not able to do it, Rev. Please use Innocence Project. I says, what if I come up with the $50,000? He wants me to give him $50,000. Now, he knows I haven't told him that I can't even get a job because they're doing background checks. He says to me, Rev, I've got trials for the next 6 months. I'm swamped, and you don't have $50K. And then I says, what if I come up with that amount? He says, if you hit 50 in cash, we could try and make it last, but it may not be enough, but I would consider it. So in actuality, he's supposed to have been representing me pro bono. That means free. And zealously. And so now, he wants me to rob a bank or something to come up with $50,000, or I'm supposed to get a deal with a cartel and carry over $1 million worth of drugs to get $50,000 and give it to him. And then what he, in his mind, he's working with the district attorney. He's going to litigate some garbage, and they're going to deny it, and they're going to conspire together to deny it. And then he's going to ask me for another $50,000 to go to appeal it to the next court. So this is the kind of games that these people play. The lawyers, district attorneys, the judge, and the law clerk. They all get down and grimy like that. I don't see how they think. When this lawyer texts me that he was paid by D.A. Bryce and Melinda Katz to abort my case upon some DNA, and he knows it was highly unethical. I asked him whether he's drunk. I reiterate. I asked him that was he drunk. I said, you just made an omission of guilt. I wish you would have never told me that. He texted this. I have the text right here. Maybe you can see it, maybe not. But here's the text message right here. I made a hard copy of it. And I got photographs of it. I sent it to all kinds of people, all kinds of agencies, and stuff like that. I recently was invited to Brad Landau's campaign party, and I told him about this corruption. And he said to me, if they really did that, they could be disbarred. I said, I have the evidence, and I showed it to him. He said, yeah, you got the evidence. They could be disbarred. Disbarred. When I was in prison, I studied law. What they did was a conspiracy. they conspired to deny my due process right, my constitutional rights to an exoneration of full actual innocence claim in an evidentiary hearing. They denied it. They falsified a letter saying that the Conviction Integrity Unit does not substantiate my claim of innocence when they didn't have any of their investigation team at the crime scene. They obstructed their knowledge of this sole eyewitness standing at a distance that was humanly impossible to do. This falls under the RICO Law Acts. Conspiracy, when you have a conspiracy, there's more than one person involved in corruption and racketeering. Yeah, racketeering. So it's just more than just being disbarred, much more. And the thing that I don't get the gist of this, all of this, is that the people who, the cops who actually kidnapped me off the streets, and the prosecutor and judge who maliciously prosecuted me, and the lawyers, trial lawyers, they are all deceased. So, I don't understand why Melinda Katz and D.A. Bryce don't want to admit that I'm innocent, that I was framed beyond a doubt, a shadow of a doubt, I was framed. Why are they trying to cover something up and I cannot harm anybody's career or reputation, because it would be meaningless to even think about it, because they're deceased in the graveyard. What are you going to do? Go over to their graveyards and arrest them? Try to take their ghosts to a arraignment court and all that kind of stuff like that? That's not happening. I think it's blatant racism as to why my case continued to linger, and nobody doesn't want to admit to the corruption encompassing my case for decades. 32 years in prison and 9 years almost still fighting for a case that should have been dismissed in the earlier stages. I shouldn't even got indicted. They dismissed the case of this female, and those transcripts were stolen too. Now, how in the heck does Bryce Benjamin and Melinda Katz believe in their mind, their sick minds, that with all this information I have, videos, text message of them paying off Eric Kleiner not to put a 440.10 motion and did not report the corruption that they're involved with. I mean, when you're on the subway, you hear it all the time. You see something, say something, and do something. They took an oath to protect the Constitution. My case is a prime example as to why these district attorneys cannot investigate their own cases, because they don't want to go against their office. But I told Eric Kleiner, I said, man, listen, man, I don't care how they exonerate me. They can throw the police under the bus, a truck, on a steamroller. I don't care. They can do whatever they want to. Those people are deceased. Can't harm nobody. They only have to mention their office. Just exonerate me, clear my name. But in their sick minds, they believe that they can go to a corrupt judge to go along with any procedural bar, because that's what they would probably try to do, come up with a procedural bar and say that I was untimely. The only reason why I could only be timely, is because they refused to give Eric Kleiner the affidavits that he requested months and months ago, and he never even tried to go any other kind of way to get the affidavits that he requested.